do you need in your estate plan? Would you be surprised to know you need quite a few documents, not just a will? Now, a will is a good place to start. It's foundational. It's something that everybody needs a will. Probate gets a bad name because of people that have to go through probate with no will. That's where it's very expensive and difficult and time consuming and very frustrating to try to probate an estate with no will. But if you have a good will in Texas written by a lawyer that knows what they're doing and it's self-proved, then it's a very simple process to get that approved by the judge. And then the independent executor can do what they need to do and get the thing wrapped up as quickly as possible. So I recommend everybody has a will. Some people need a trust to avoid estate tax or to protect a person who can't handle their money or for various reasons. Sometimes a trust is needed, but never just to avoid probate. And I talk about that separately. But there's also people that own a family ranch or farm or a business, or they own rental properties. That is a business that could be run as a family limited partnership or an LLC. And that's an excellent way to avoid creditors. It provides you that protection, and it can be used the same way as a trust to put all your property in that business name, and it passes through the business to the next person who's in charge of the business, and it does not go through probate. The business continues continuous operations after you die, just the next person takes over running the business. So sometimes that's a better solution than a trust. You have to look at the fact that if you set it up as an LLC, once you're gone, who's going to be the managing person? And what kind of voting rights do people have? How much are they going to have to get along in order to get business done? Also, there's other documents you need. You need powers of attorney to avoid expensive guardianships, medical power of attorney, statutory power of attorney. If you want to be cremated, you should have a designation of agent to control your remains, to make sure that your ashes go where you want them to make sure that you actually get cremated and not buried. Or you can do that also to direct where you want to be buried, or things like that, what you want to have in your funeral. That puts one person in charge. And so that's a good document to have. You could do a self-designation of guardian if you think that someday they might be asking for you to have a guardian and you know certain people you would want and ones you would not want. You can specify that in a document that the court will honor as long as the person that you're saying you want to be guardian is qualified to be guardian. The court's going to honor your preference on that. And you can disqualify people from being your guardian if you just don't like them and you're afraid they want to take over. You should have maybe a directive to physicians if you feel strongly you don't want to be kept alive on life support. A lot of people skip that one because it's covered by the medical power of attorney. The difference being the medical power of attorney, the agent that you name makes that decision for you at the time based on what's going on at the time. They're still supposed to do what you would have wanted. The directive to physicians takes it out of the hands of your family and puts it in the hands of the doctor. The doctor decides that you have reached a certain condition that justifies pulling the plug. Then the doctor tells the family, this is what we're going to do. We have the directive to physicians telling us that they don't want to be kept alive on artificial life support, and so we're going to pull the plug. So in one sense, it's not something that a lot of people want to leave in their doctor's hands. They don't know their doctor that well, and besides that, they don't know exactly what the situation's going to be. What kind of terminal condition am I going to be in? How bad do I have to be before they decide to end my life? And what chances are there that I might actually recover? If you're letting a family member make that decision, that's awfully hard emotionally on your family. And some people know that, their family just could never do that. Even though you wouldn't want to be kept alive indefinitely with no hope, and it's very expensive, but they are not going to have the courage or the emotional capacity to pull the plug. So then you might want to just do a directive to physicians. You might want to look at if you have adult children, 18, 19 years old, going off to college, you would want your children to sign a HIPAA release, a medical power of attorney, over to you so that you could find out what's going on with them if they were in a car accident or something. And, the doctors are saying, well, privacy law says that we can't tell you anything about what's going on with your son or daughter. If your son or daughter is a minor, then you might want to do a medical power of attorney for them, designating another person if you were not available. Something happens to you and you can't consent. Who has the power to consent for medical treatment for your children? So you can do a medical power of attorney for your children so that there's somebody who's available in case you can't do it. Or maybe if you're deployed overseas or just not going to be able to be around for a while. Those kind of things that you might want to look at. Also, a transfer on death deed. We can do a revocable transfer on death deed or a ladybird deed, which is similar, except it's not revocable. And that will make your house pass automatically to someone when you die without having to go through probate. If you own other assets, those would still have to go through probate. But what a lot of people have is they just have a house and a bank account, maybe a life insurance policy and a few financial accounts. All your retirement plans, financial accounts, 401ks, and your brokerage accounts can generally have a survivorship agreement. You name a joint person with right of survivorship or a pay on death person, a beneficiary, and that is a contract between you and the company that's managing your money to say whenever you pass away, then they're just going to automatically turn the account over to this person that you have designated. So that does not go through probate. And if you've got survivorship agreements on all your financial accounts and a transfer on death deed filed at the courthouse before you die, it may be that you don't own anything else that needs to be transferred, and so there's no probate needed. That's a good way for most middle-class people to avoid probate, and it has nothing to do with a complicated trust. So there are many different documents that you should discuss with your attorney about which ones are right for you. And whenever you go to sign your will, you can have all these other documents ready, sign them all at the same time, keep them all together.